What are the legal gaps for private military companies? Have you ever wondered about the role of private military companies in modern conflicts? Today, we will discuss the legal gaps that exist for these entities under international humanitarian law. Private military companies, often referred to as PMCs, operate in a complex legal environment. This environment reveals significant gaps in accountability and regulation. First, let's talk about the unclear legal status of PMCs. These companies and their personnel do not fit neatly into traditional categories defined by international humanitarian law. Most employees of PMCs are considered civilians under international humanitarian law, yet they frequently engage in direct hostilities or military support roles. This creates confusion regarding their rights and protections. The principle of distinction, which is meant to protect civilians, becomes complicated when PMCs are involved. Next, we have the issue of accountability. A major gap is the criminal responsibility of PMC personnel for violations of international humanitarian law and human rights abuses. Unlike state military forces, PMCs often operate beyond the reach of effective criminal prosecution. In some cases, legal defenses like government contractor defense have been used to avoid accountability for serious offenses. Victims of these violations often find it difficult to seek justice through civil courts. Prosecutions of PMC employees are rare, even when military personnel involved in similar incidents face charges. Another significant gap is the weakness of international regulation. There is currently no comprehensive binding international treaty that specifically regulates PMCs. Existing frameworks, such as the Montreux Document and the International Code of Conduct for Private Security Providers, provide guidelines but lack enforceability. Many states have not implemented sufficient national laws to regulate PMCs effectively. This allows companies to exploit plausible deniability regarding their involvement in conflicts and civilian harm. The involvement of PMCs can also impact the protection of civilians. Their actions often make it difficult to attribute responsibility for civilian harm. Data on such harm is rarely broken down to identify the actions of PMCs. This lack of transparency increases risks for civilians and limits their access to remedies. Additionally, the traditional concept of command responsibility is challenged by the presence of PMCs. Their personnel are not always under clear military command structures. This complicates the enforcement of commanders' obligations to prevent and punish violations committed by forces under their control. To address these gaps, there is a pressing need for clearer legal definitions regarding the status of PMCs and their personnel under international humanitarian law. Stronger mechanisms for accountability and binding international regulations are essential. States that contract PMCs should ensure compliance with international humanitarian law and human rights law. This includes implementing oversight and judicial processes. Enhanced transparency and reporting on PMC activities are vital for improving civilian protection. In summary, the legal gaps for private military companies stem from their ambiguous status under international humanitarian law, lack of enforceable regulations, difficulties in holding personnel accountable, and challenges in protecting civilians. Addressing these gaps is essential for ensuring that PMCs operate within the framework of international humanitarian law.